Okay, this is the Justice panel. I'm Lars Waldorf again. I'm going to say a couple of words and then introduce the panelists. And then after the panel is concluded, we will be doing a premiere screening of Anneke's film, The Notebooks of Memory, which I want to say is not the film that is being shown at the Human Rights Watch Film Festival tomorrow and Sunday. In other words, you should see both films. So I would hope you would stay for her film tonight, and you would go to see her film either tomorrow or Sunday. I was a civil rights lawyer in the US for 10 years, and like many lawyers, and there are some here on the panel, I quickly became very cynical about justice. I would tell victims of human rights abuses or civil rights discrimination in the US, hey, I can give you the law, but if you want justice, you better wait for the next life. Well, Alison wouldn't wait. And perhaps because she wasn't a lawyer, she was a true believer that impartial justice could be achieved in this life. She helped convict many of the Genocidaires at the International Criminal Tribunal for Rwanda and in several transnational trials, not just as an unpaid expert witness, but also as a key prosecution strategist behind the scenes. I think a lot of the cases wouldn't be where they wouldn't have ended with convictions if she hadn't played a major role behind the scenes. And I was glad that Nigel mentioned this. It was indeed amazing to see her on the witness stand, and I had that privilege several times as well. And it was like what you imagined a graduate seminar was supposed to be like. But it was also performance art, because she would go on for hours or even days on end without any notes, and swatting back the some of the ridiculous questions from defense counsel and even from the judges who didn't know very much often. And yet she fought just as tirelessly and fearlessly for those who were unjustly accused of genocide. I remember seeing her testify as the only defense witness for Father Guy Tunis, a Belgian priest in a gacaca trial staged by the Rwandan government. And again, that's my photo on the cover, and it kind of is Alison at her finest. I think it was like 5 hours into that particular gacaca, and there had not been a single voice raised for Father Guy Tunis, and she stood up and she raised hers, and then she dealt with the consequences afterwards. Her commitment to justice for the genocide also didn't blind her, as it did so many others, to the war crimes and human rights abuses committed by the current Rwandan regime. I saw her at a conference last June where she criticized Rwanda's justice system, basically drawing on the report that people have already mentioned, the Law and Reality report that Human Rights Watch published last year. The Minister of Justice, an otherwise very reasonable and very much an intellectual, he was so angry with her at the conference that he accused her of becoming a spokesperson for genocide ideology. And after that conference, as has been mentioned, she was not allowed back into Rwanda. When I saw Alison the night before she died, and I saw her with Sarah Matthewson from Human Rights Watch and from Kirli Pels, who you heard from earlier, she told me, or she told us, that she was starting to get cynical about justice. But that very uncharacteristic mood didn't last for more than about a minute before she launched into how she was defending an exiled Rwandan academic in the US who was falsely accused of genocide, and how she was still gathering evidence about RPF war crimes. This panel only touches on genocide justice, universal jurisdiction, the ICTR, national prosecutions, and also gacaca. The panel now picks up very nicely, I think, from Phil's talk this morning, and also forms a bridge to Anne's film this evening. I want to introduce the next panel. And all the panelists here knew Alison, and some of them knew her very well indeed. First speaker will be Carla Ferstman. Carla is the director of REDRESS, which has it's an incredible organization that works for victims of torture. If you care about the issues, you should visit their website regularly. But they have also organized conferences and published reports on universal jurisdiction for Rwandan genocidaire, and about the transfers, and about the state of justice for Rwandan survivors. They did that in collaboration with African Rights. Our next speaker is Don Webster. Don is the lead prosecution counsel for the trial of the Prosecutor versus Caramera, which is currently pending before the ICTR. He joined ICTR way back in 1999. He's one of the lifers almost. He was initially in Kigali, Rwanda as a senior legal advisor and head of their legal advisory section. And in 2003, he was transferred to the trial section in Arusha. And I have very fond memories of meals with him and Alison in Rwanda. There was one where the issue came up about the Swiss military tribunal that tried a Rwandan for genocide. And we were at the dinner table, and Don reached back and opened the credenza and pulled out the case. And I think he had planted it just to impress Alison, and she was suitably impressed. I was too, actually. Actually, I was jealous as hell, but that's a different story. Klaas de Jong was one of the first people I met when I came to Rwanda to work for Human Rights Watch, and we had we were eating lunch at the Chez Lando, which has a lot of historical resonance for people who know Rwanda and Kigali. And about 2 minutes into the conversation, I realized that I knew very well who Klaas was, because when I spent a little time in South Africa, he was holed up in the Dutch embassy for having been working for the ANC, gun running and doing other various revolutionary activities. And it's also great to welcome him here, because this place, the Institute for Commonwealth Studies, has a real tie to Ruth First. And if I remember rightly, Klaas got some of his training as an anthropologist on the hills in Mozambique with Ruth First. And I think partly out of that experience, Klaas went from being a participant in observation to being more of a participant in revolutionary struggles. From 1998 until 2005, Klaas was the director or the coordinator of PRI, Penal Reform International's research program into Gacaca. And I think he really laid the foundations for what Phil and I and lots of other researchers have since built on. I don't think we would be anywhere near where we are in our understanding of Gacaca without the contributions of Klaas and his team at PRI. Karina is an old colleague from Human Rights Watch. She's been a human rights researcher and campaigner based in London for many years, from '95 until 2000. She was Amnesty International's researcher on Rwanda. From 2001 to 2005, she was a researcher at Human Rights Watch. She mostly worked on Nigeria, but every chance she got, she came back to the Great Lakes, and she did come back. And then since mid-2005, she's been leading Global Witness's campaign on the links between the exploitation of natural resources and armed conflict in the Democratic Republic of Congo. She also, I've always told Karina that she will go to heaven for one thing, well, maybe more than one thing, but she translated Sibomana's book, Hope for Rwanda. And this is something that I got brought up earlier by Karen, but for those who care about Rwanda and want to know more about Rwanda, Hope for Rwanda is probably the best book on Rwanda by a Rwandan human rights defender. And the way I got my job with Alison at Human Rights Watch is I managed to say that I thought it was the best book during the interview, and she gave me the job. Actually, she had me go through many other hurdles first, then she gave me the job, but that was Alison. Also, Karina did enormous amounts of research into the lives of prisoners in Rwanda and has published a remarkable book, The Chateau. We were honored to host the launch for it here last year, and there are copies available. So with those rather lengthy introductions, but you have to understand these are old friends and colleagues, let me turn it over to Carla. Thank you.
Can you hear me? Yes?
Yes.
Good afternoon, everyone. REDRESS is a very specialized NGO that works to assist survivors of torture in their quest for justice. So the type of work that we do, we work with individuals and communities who are seeking to obtain justice, and we try simply to find locations and avenues in which justice can be served. It sounds like a simple prospect, but it tends to be very complex, particularly when it comes to international crimes such as torture or genocide, crimes against humanity, etc. When it comes to genocide in particular, justice is always going to be a very, very daunting prospect. And in the case of Rwanda, this is of course no exception, as I'm sure this whole panel will aptly demonstrate. What I'm going to talk about in my presentation is the international side of the justice process, not the work of the ICTR, the Arusha Tribunal, but the practice of countries where genocide suspects have been found. So if a genocide suspect was found in London today or tomorrow, what would happen? We have many practical cases about this, and there's quite an interesting, quite a variety of issues that have come up in relation to the quite extensive practice of individuals, genocide suspects found not only in Europe, but in a variety of different places around the world. REDRESS became involved in this type of work quite a number of years ago when a genocide suspect by the name of Tarsis Muvunyi was located in London, in South London. He was just living in South London. We were contacted by the organization African Rights at that time with certain factual allegations relating to this individual. These allegations were eventually conveyed to the Metropolitan Police here in London, and he was eventually transferred to the Arusha Tribunal for trial. The Arusha Tribunal, it's fair to say, was really convenient for states, such as the United Kingdom, but certainly not only the United Kingdom, where genocide suspects were being located. States didn't want to go through all the difficulties and the expense of investigating with a view to having a trial in a foreign country. So transferring a suspect to an international tribunal in Arusha was certainly the thing to do, and the easiest, least sensitive option. But then the Arusha Tribunal stopped taking new cases, and I'm sure we'll hear a little bit more about this. It's in the process of closing down and is in midst of its completion strategy. So it's trying indeed to send some of its caseload to other countries willing to prosecute. But at the same time, there are still hundreds, if not thousands, of genocide suspects around the world. So what to do? As far as we know, there are genocide suspects concentrated in Africa, in Democratic Republic of Congo, Zambia, Malawi, Mozambique, in Europe, Belgium, France, Netherlands, Italy, UK, Norway, North America, both Canada and the United States, as well as Australia and New Zealand. So there's a really wide spread of individuals in these countries. The question for states where these people are located is firstly what to do, and how to go about it in a sensitive, reasonable way. The obligations under international law are quite clear, at least on the surface. International law requires that countries that are harboring genocide suspects ensure that these types of suspects don't escape justice. In general, this means that states should have the legislative basis, so the laws, to investigate and prosecute genocide suspects where those suspects are located, if there is no possibility to extradite them to some other location. The basis upon which states would exercise this type of jurisdiction is typically referred to as universal jurisdiction, which is the principle that where crimes are so terrible, so heinous, they offend the international community as a whole. And all states, because of this offensiveness to the international community as a whole, all states have a duty to investigate with a view to prosecuting. There have been several genocide prosecutions in different countries, though the numbers of prosecutions pale in comparison with the number of suspects. To date, we're not aware of any investigations in African countries, aside from Rwanda, of course. In Canada, there's one genocide prosecution that's currently underway, and investigations are actively being looked at in another case. In the USA, there is a number of investigations that are underway, both for genocide as well as violation of immigration rules. Here, as we might know, after the genocide, many individuals left Rwanda. Some sought refugee status in the countries where they went to. Under the Refugee Convention, individuals are not, it's possible to deny someone refugee status on the basis of if they're said to have committed serious crimes, including genocide. So in some countries where it's been impossible or difficult to entertain prosecution, individuals who have obtained refugee status, there are processes to undo that refugee status. In Europe, in the past few years, at least 30 investigations have been opened against genocide suspects in at least 9 European countries, which is quite a lot. But to date, there's only been very few successful prosecutions. We have 2 successful prosecutions in Belgium, 1 in Switzerland, and a number of cases are pending. And actually, stay tuned to your newspapers for next week, because there's a case in the Netherlands which is due to have its decision, I believe, on the 24th. But universal jurisdiction cases are typically extremely difficult for a number of reasons. Firstly, for an investigator, a typical investigator in a European or other country around the world will have quite a difficult time to understand the context of what happened in Rwanda. In the case of the United Kingdom, that is further complicated when it comes to trial, and you have a jury trial, and regular people are trying to come to terms with the context of genocide in some country very far away, which they have very little understanding of. In the one universal jurisdiction case that proceeded in the United Kingdom, which is a case of an Afghani warlord, the jury trial ended up being blocked. In other words, they couldn't reach a verdict. And the prosecution brought the case a second time. And on the second time, the individual was convicted and is serving out a 20-year sentence. But it was seen that with these types of cases, it's very difficult for regular people to really appreciate the evidence. But in the case of Rwanda, it's also very difficult. Most of the people in the room will know very well about what happened during the genocide. Witnesses were not sitting there taking notes or taking pictures. anyone who wasn't involved in the killings was hiding or was fleeing. So the idea that there are many, many witnesses available to give evidence which is sufficient to convince a court of law is quite wrong. It's quite difficult to get a successful prosecution, and particularly for countries which have one case as opposed to a whole series of cases. It's quite difficult to get the level of expertise that is necessary to understand the complexities about how to go about proving certain types of evidence. There's also a number of procedural challenges with respect to how to get the evidence. One can imagine that there would be a prosecutor or an investigator in a country in Europe who understands a certain fact pattern, but they actually would need to go to Rwanda to investigate and to meet with victims or witnesses to confirm and to build a proper prosecution case. But that process can be rather complex, and there have been difficulties in the past. But another problem, which is underscored by the situation we have here in the United Kingdom, is legislative, is the adequacy of the legislation. Many states, surprisingly, don't have the ability to mount a successful prosecution for genocide. And the reason for this is quite simple. The Genocide Convention in 1948 did not have a universal jurisdiction provision. The Genocide Convention simply said that states have an obligation to prosecute or to send individuals to an international tribunal. They didn't refer to what came in many other treaties subsequently, an extradite or prosecute provision. So when states ratified the Genocide Convention, they simply copied the language in the Genocide Convention, put it into their domestic law, and as a result, many states didn't naturally have a provision which gave them authority under treaty to mount prosecution. In the UK, this was made worse by the fact that the Geneva Conventions Act only recognized the ability to prosecute crimes in an international armed conflict, not a national armed conflict. So the view was taken that it wouldn't be possible to mount a prosecution for war crimes. In 2001, the United Kingdom government put in place a new law after the adoption of the International Criminal Court, which did provide for universal jurisdiction. But as a very general principle of law, here and in most countries, it's impossible to look backwards. So the law is effective from 2001 forward, but is not capable of looking backwards to 1994. Hence, there's a gap. Hence, if the extradition appeal, which is currently pending against 4 Rwandese genocide suspects in this country, fails, it will not be possible for this country to mount a prosecution for genocide, which is quite a serious problem. Another challenge is capacity. Many countries have investigations which have been opened in relation to genocide suspects in a variety of different countries. But once an investigation is started, particularly in a system with a civil law tradition, the investigation has to be given to an investigating judge to take up the investigation and to proceed with the collection of evidence. The investigative judges in France, in particular, have not been given the resources necessary to travel to Rwanda. The staffing is insufficient, they don't have time, there's a huge backlog, which means that even though there is, in principle, investigations opened, which are in principle proceeding, the amount of work so surpasses the amount of resources that are available. With respect to extradition cases, here, I don't know if it was talked about already this morning, but Rwanda has been issuing extradition requests for genocide suspects abroad with increasing frequency. Most of these requests, aside from the United Kingdom, which has accepted to send 4 individuals back to Rwanda, but this is under appeal. But most of the other countries have denied the requests, or the requests are still pending. And the Rwanda tribunal itself has so far not decided not to send cases back to Rwanda. There's a variety of reasons for this. And some of it relates to fair trial issues. Some of it relates to technical aspects of the law, which are in the process of being fixed, and the situation is evolving all the time. But for the moment, it's fair to say that there is a gap. In other words, many countries are not yet seeing the possibility to send genocide suspects to Rwanda to face trial because of a variety of different issues. But at the same time, some of these countries are not yet taking up these cases themselves. So the result is a big hole where we really should have justice, and a big notice board which can read impunity. The Rwandan government has not challenged the respective countries' jurisdiction under international law to bring genocide suspects to justice in a general sense. In a general sense, the Rwandan government has accepted that there will be suspects in a variety of different countries, and genocide prosecutions should in general proceed. But in a series of recent events, the position of the Rwandan government on universal jurisdiction prosecutions has evolved, and it's interesting to just consider this briefly. And there's a variety of reasons for the evolution of the perspective of the Rwandan government on universal jurisdiction. First, in Germany, there was the release of Kalix Mbarushimana, who, as many of you will know, is a leader in the FDLR, who Rwandan government had requested his extradition, and Germany, on the basis of the fact that the Arusha tribunal had said that it wasn't ready yet to send people back to Rwanda, Germany said no, well then we're not ready either. And didn't really look at the case in much detail, just said no, we're not extraditing, but just let him go. And so now the individual is back in France. Second is the German decision to transfer Rose Kabuye to France for charges relating to the downing of the plane which led to the start of the genocide. And the third is the Spanish arrest warrants, which many of you will know about, against a large number of Rwandan soldiers for crimes committed at the end of the genocide. As a result of these incidents, Rwanda initiated a process before the African Union, leading it to issue a resolution on the abuse of universal jurisdiction. The Rwandan government statement refers to universal jurisdiction as, and this is a quote, "Foreign judges seek to recolonize Africa through a form of judicial coup d'etat under the guise of judicial independence and universal jurisdiction. These judges seek to exercise political power over independent sovereign states, hiding behind judicial independence, intentionally abused to serve their neo-colonial ambitions to control and dominate the targeted countries." There's an ongoing process at the African Union and the European Union to deal with this development. But I must say it's a very sad state of affairs, because certainly universal jurisdiction, given the current challenges with effectuating extraditions to Rwanda, given the current reality of the closure of the Arusha tribunal, universal jurisdiction is a key way by which certain suspects will be investigated with a view to prosecution. So let's keep this in our toolbox as something to take away our placard which says impunity. Thank you.
Good afternoon. I want to begin by thanking Lars for this opportunity. It really is a privilege for me to address you and introduce Alison de Forge. And as he's already said, there's nothing I can say that would supplement what he and some of the other people have already said. Alison was so humble, so giving, so gifted, and just so brilliant that it was really a privilege to know her and to work with her. And I actually met her before I met Lars, but I do remember meeting Lars again through Alison, because he thinks he got his job from recommending Silvana's book. And what I recall is Alison told me, I'm coming to Kigali, and I have this guy that I want to take out for dinner. Can you meet me and we'll take him out for dinner because I'm going to take him up on the hills to see if he doesn't mind getting his shoes dirty. And so I'd seen Lars before, but the first meeting where we actually had a tete-a-tete was with Alison over dinner, because we were sort of seeing how good will this guy fit into the hills of Rwanda, which is where he has to do his work. Because even though he's bright, that's not all that it takes to do work for Alison de Forge. So that's the type of person she worked with. Karen mentioned that she was a gossip, which she definitely was. But she was a very principled gossip. And she had an uncanny ability to make you feel like you are the only person that she has this type of relationship with. So, it's surprising to me to see all these folks who have the same relationship that I had, with Alison, because we're all thinking that we're the only ones that she relaxes with and sort of spills her guts to. But I don't know what I can say to express what a tragic loss it is, because she was literally an encyclopedia on the Rwandan Great Lakes, and definitely Lars is correct. She was a behind-the-scenes operator in the tribunal, in the Office of the Prosecutor. In some cases that could not be launched without the assistance of Alison de Forge. When we thought we had no witnesses, we just, Alison said, yes, you do have a witness. This person can't go here and do this. And she made sure that the Office of the Prosecutor lived up to its potential, because you are not just disappointing yourself. You were disappointing this conscience that created this institution, because she was there before there was a tribunal. She, we all know her writings when the conflict was in progress, but then she was very instrumental in lobbying the powers that be to create this institution, to make sure it had funding when it was heavily criticized. She came to its defense. So she was our conscience, and I will miss her. And I'll say other things if I have time when I get to the end of my talk. In fact, in trying to address the International Tribunal and Gacaca, it's fitting that I do so at Lars's invitation, because my first involvement or exposure to Gacaca was with Alison and Lars. I think we went to Butare, and I went as a deputized member of Human Rights Watch, because the ICTR was not welcome in Gacaca initially. I'm not certain to what extent we are welcome even now, not officially. So I attended Gacaca sessions with Alison and Lars. So I've been working with the tribunal for the past 10 years, initially in Kigali for 5 years, and then most recently in Arusha as a part or the leader of the Karamera trial team. And this is a case that has a long history in the tribunal. What is key about what I'd like to say is that I don't have a comprehensive analysis of Gacaca. What I have is my perception through the prism of the work that I do on this specific case. When I arrived at the tribunal in 1999, the office was at a major crossroads. We had gotten a major boost because Akayesu judgment had been delivered a few months before. Jean Kambanda had been arrested. He was collaborating with the tribunal. This was the former Prime Minister of Rwanda, a major insider into how the interim government operated. He agreed to cooperate and plead guilty, and gave us maybe 60 or so days of interviews that really spilled the guts of how the interim government operated to organize this massive genocide from April to July. The unfortunate thing, however, was that the trial chamber condemned him to life imprisonment, which was the maximum sentence, and there's nobody in the world that participates in their own prosecution and expects to be sentenced to the maximum. So his reaction at the time, which was quite natural when you think about it, was to suspend his cooperation. And we had a number of cases that had been built around Kambanda, and a number of arrests that were the result of information that he gave to us that led us to other witnesses that led us to make arrests of significant political leaders and military leaders. And all of those cases were going to be grouped around Kambanda's prosecution testimony. And the model was going to be Nuremberg, because when you discuss international justice, Nuremberg, for good or for bad, is the benchmark. We wanted to have a prosecution on the scale and monumentality of Nuremberg in Arusha, so we're going to have 29 defendants grouped in one case with Kambanda as a key witness. The trial chamber, or the confirming judge, rejected that on procedural grounds, and when I came into the office, I was part of an effort to make a second foray to cobble together a huge mega trial. Instead of being 29 persons, it was going to be around 10 or 15 persons, still with Kambanda as the central witness. That also, thank goodness, was shot down, because we have cases now with 3 and 4 accused, and they run on for 4 or 5 years, and these cases ended up being much more complicated than we had anticipated. But the major hurdle that I had to deal with was that Kambanda was no longer testifying. We had all of these indictments that were preparing to go to trial, and how were we going to make the link between these national leaders who had little to do with killing on the ground and the crime base? So when there was this discussion of gacaca, and when the Rwandan judicial system was starting to pick up, which was around 1999 or 2000, bells rang off, because now we had the hopes of finding lower-level perpetrators in the Rwandan justice system that would then give us the insider testimony that we used to make the link between these national leaders, who none of the rest of the saw because they're behind the scenes, and these Rwandan insider witnesses coming out of the Rwandan judicial system was going to be how we responded to losing Kambanda as our main witness. So I had great hopes for gacaca. Gacaca was going to open up a wellspring of information and, give us the ability to prove our cases. Well, viewed through the prism now, 10 years later, I must say that I'm very skeptical about gacaca's capacity to help the prosecution, and I've actually arrived at the opinion that it has undermined my ability to prosecute the Karamera case effectively. Now, I'd like to be very explicit about how I arrived at these conclusions, but I'm limited because the case is ongoing. We're in the defense phase. I can talk about things that are in the public domain, but I can't be as explicit as I would like to be. But there are two crime theaters that we are concerned with in the Karamera case, or among others, but one is in Rwanda and the other is in Gitarama. And this chip of what was initially a larger case, with facts in Rwanda, overlaps with other cases that were initially intended to be part of one mega case. So you have the same facts in Rwanda that are replicated in 3 or 4 other cases, one of which was the Kajeli Jelly case. So we went and we found insider witnesses, former Interahamwe, who testified in the Kajeli Jelly case. Kajeli Jelly was a burgmaster, much closer to the activity on the ground than someone like Joseph Nzarera, who's on my indictment, or Casimir Bizimungu, or Augustin Bizimungu, or high-level people who did not have to go down to the roadblocks or to the killing scenes. And in Kajeli Jelly, we could couple the testimony of victims with the testimony of these inter hominem guys, and the evidence would be consistent, and that would lead to a conviction, because we had the victims talking about what they suffered, and they didn't see, the leadership, because they were, those that survived to tell their story, those that were farthest away from the killing, but they could see the massacres. And then the insiders who would say, well, yes, Kajeli Jelly and Inzerer and all these guys are the ones that gave us the weapons and mobilized us and trained us and so on and so forth. In the Kajeli Jelly trial, the prosecution, because of the procedural disclosure regime in the ICTR, is obligated to hand over to the defense all of the prior statements of our prosecution witnesses. And the only statements we had when Kajeli Jelly was going to trial were the statements that these witnesses made to our investigators. But by the time we get to the Karamira trial, 10 years later, and after these cases are making their way through the justice system in Rwanda, and in my trial chamber, which has a much more expansive disclosure regime than in the Kajeli Jelly trial, we are obligated not only to disclose the statements that we have in our files, but we have to go into Rwanda, into the Gacaca courts and into the Rwandan prosecutor's office and get all of their files on our witnesses and hand them over to the defense to arm the defense with the ability to cross-examine these witnesses effectively. And the way we take statements in the OTB or in the ICTR is quite different from the way witnesses are examined in the formal Rwandan justice system and in the Gacaca system. So witnesses that gave compelling evidence the first time around in Kajeli Jelly are now compromised when they're testifying for the third and fourth time in a trial such as mine, which is one of the last to make its way through the pipeline. And when, on the one hand, I expected Gacaca to provide a volume of information and evidence that we could use, that information is more a weapon in the hands of the defense than it is in the prosecution. And in Rwanda, whether it's in the formal system or in the Gacaca system, witnesses are not accused with specific crimes. They're given an opportunity to create their own files and to confess. And nobody that has done any wrongdoing admits to every single thing that they've ever done. And when you have 5 or 6 different inter hominem guys that have acted in concert, and one is saying, well, yes, I was at the church and I saw A, B, C, and D, and they did this, but I didn't do anything, but I was there. And then you go to the second guy, and he says, well, yes, I was there, and I saw A, C, D, and E. I didn't do anything, but I saw what these guys were doing. And then you take all of that information together, it ends up in being a weapon in the hands of the defense, because all of these prosecution witnesses have now compromised each other and compromised themselves. They also do not make full confessions. So the statement in year 1 is significantly different from the statement they make in year 5. And they're making statement after statement after statement. Well, fine, you get more and more information, but that information now is not helping us in the courtroom in my trial. Beyond that, when these witnesses testify the first time around, the cross-examination is limited to the information in the hands of that particular defense team. By the time you get 4 or 5 trials down the road, there's more information. The witnesses are cornered, and in the very process of the trial that I'm trying, by this time, Gacaca has gone through a few series of changes itself. These witnesses who came to us initially as detainees are now free in Rwanda. They have been released. They had confessed. They had gone through some sort of adjudication, and now they're no longer detainees in Rwanda. The information that we developed in my case, in the hands of the defense now, because all of this stuff is known to the accused, filters its way back to Rwanda, informally. Filtered back to Rwanda, it becomes a vehicle for people in that community, their home communities, to re-accuse them again in Gacaca. So the same individual, who certainly these are bad guys. There's no disputing the fact that these are killers, but they happen to be the killers that could provide the key to me in my prosecution, because they're giving me good evidence against people at the very highest levels of authority, but Gacaca is undermining their credibility. I'm not saying that Gacaca is bad, and I'm not making a broad stroke critique of Gacaca. All I'm suggesting to you is that the way that the international jurisdiction interacts with Gacaca has undermined my ability to secure good prosecution evidence in my case, which is it's a pretty important case. Gacaca, in this particular context, and I'm not saying this is the case all across Rwanda, but in Ruwenzori, which was a stronghold of the MRND party, which was really Inzira's backyard, he and his cohort continue to exercise influence. Because you have an RPF government does not mean that this former regime doesn't have ties and influence in those communities. Gacaca can be manipulated by anybody that has power, however power is defined in the community where it's situated. So it's not just a vehicle in the hands of the RPF, it's a vehicle in the hands of whoever gets to be a judge in Gacaca, and the criteria that is listed is not the criteria that's necessarily applied. So to hear the witnesses recount, and I haven't verified this, so I can't say that this is, the analysis, but to hear these witnesses, when they testify in Arusha, even though they're testifying under a pseudonym, the information about them is circulated back to their communities by the accused. They are re-accused in Gacaca, and then they're re-incarcerated. So it's bad enough being, from the perspective of the prisoner, being in jail for 10 years. You get out, you don't quite understand why. You're told that if you confess, you can get out. You're out. Well, now that you're out, you don't want to go back in. And that's what has happened, because Gacaca is manipulated by the accused from Arusha. And in this particular instance in Ruwenzori, where there was a shared intimacy between all of the killers and the victims and the authorities, which is unique to Ruwenzori because it was so dominated by the MRND party, and it's such a small-scale community. Tutsi were only 2% of the population. They had been attacked in 91 and 92. All of the victims and their families know these Interahamwe guys because they had been harassing them and attacking them for the past 3 or 4 years. And it's a small enough community that everybody knows everybody else. So on the one hand, you have family members of the accused who have inserted themselves somehow into the apparatus of Gacaca, and then you have the families of the victims, of the survivors, who aren't happy about having mass murderers and rapists released back in their community to live next door to them. So the survivor community as well, now recharges these witnesses with additional crimes that they had not confessed to initially. And you have this unfortunate identity of interest between the survivor community and the friends and family of the accused. And they don't get together, but they demand the same things of this mechanism of Gacaca, and it ends up slamming the accused. And then when you look at the issue of rape, rape is a Category 1 offense. Nobody confesses to rape. But they all committed various acts of sexual aggression that come to light in Arusha when they're testifying supposedly anonymously. Gets back to, so it's a major problem, and it undermines my ability to do my job as the way I'd like to. Gitarama is another example, but a very different example. And in that context, Gacaca, to me, operates as a historical erasure. So in the one context, my job as a prosecutor is to enforce a regime of accountability, to end the cycle of impunity, and then to create a historical record so that these unfortunate facts of the past cannot be denied. In Gitarama, I find that Gacaca operates as a historical erasure of resistance to the genocide, which is an element in my trial. And that brings me to what I recognize more and more is the importance of the Akayesu trial judgment. When the Akayesu judgment was delivered in 1998, it was, recognized for a contribution to international criminal law, especially with regard to the criminalizing of rape as an instrument of genocide, but was also criticized as why is the ICTR going after these fairly low-level perpetrators, because he was only a burgomaster. But the Anneke trial, as far as I'm concerned, is the key to explaining the whole structure of the genocide in Rwanda. And that's because the genocide was not simply, an attack against the Tutsi. Well, of course, it's an attempt to destroy the Tutsi as a group. But it was also a way of resolving the political conflict between the north of the country and the south of the country. So in Akayesu, you had a situation where the prefecture was dominated by the MDR, which was an opposition party. And I'm not suggesting that all 18 burgmasters in Gitarama were against the MRND, because the MDR party had split, and there were a few of them that had aligned themselves with the MRND. But for the most part, the bulk of the burgmasters in Gitarama were against the genocide. And in the initial days, they put up roadblocks, yes, but they were good roadblocks. They were roadblocks that prevented foreigners or strangers from coming into Gitarama because they wanted to maintain peace. They wanted to prevent Interahamwe from Kigali from coming into Gitarama, so the roadblocks were there to protect the local population. There was no Interahamwe organization as such in Gitarama. In fact, Interahamwe leader, Silas Kubimana, was chased out of Gitarama. He had to relocate to Kigali because his life was threatened in Gitarama. So Gitarama resisted the genocide, and it wasn't until the 18th of April, after the interim government had relocated into the heart of Gitarama and broke the back of the resistance of the local authorities in Gitarama, that the genocide could continue in Gitarama. So when you have local, regional authorities from Gitarama testifying in our cases, and in the Akayesu case, because we took witnesses from Akayesu in the Karamira case, you have witnesses that were called for the defense and for the prosecution, giving consistent accounts and consistent with the prosecution theory, which is that Akayesu was pretty innocuous up until the 18th of April, and it was only when the interim government brought him into a meeting and set everybody straight about what they were supposed to do and what the expectations were, that he changed his orientation and then started to support the genocide. But what happens after you have two witnesses in particular, one testifying for the defense, one testifying for the prosecution, who testified in that case as free persons, it could be suggested that because they gave evidence that some would interpret as favorable to Jean-Paul Akayesu, they were arrested in Rwanda subsequent to their trial testimony in Arusha. Arriving at my case now, this witness, who had testified in Akayesu as a free person, testifying in my case as a detainee, significant authority, Category 1 offender by the definitions of the Rwandan law, I am under an obligation to find all of his judicial records and his Gacaca records to the extent that they exist in order to hand them over to the defense. But of course, in the process of doing that, I review them with the witness. And unbeknownst to the witness, there's a memorandum where he is exculpated of any wrongdoing in Gitarama. He had been locked up for at least 6 or 7 years. His case had been investigated. He had been showing up in court, being brought to court, and the prosecutor couldn't find anything to charge him with, which was a legitimate and a correct exercise of their prosecutorial functions, because they had someone who they could not build a case against, and they should have released him, which is what the memo, and there were several in the file, had authorized or directed the authorities to do. And the witness kept telling me, well, they keep telling me I'm going to be released, but I don't get released. And then they send him to Ngando, a solidarity camp. He expects to be released, but he's not released. Well, why is he not released? Well, Gacaca says that, no, he should not be released. Well, how does Gacaca procedurally insert itself? He's a Category 1 offender. He should not be subject to Gacaca. Gacaca is only concerned with, at that time, Category 2 and below. The formal judicial system says, not that he's innocent, but they don't have evidence to accuse him or hold him and he should be released, but he does not get released. I make inquiry because I'm trying to follow up on this witness, and I'm trying to, aside from my genuine concern for this individual, it certainly would help my case to have a witness who testified under an accusation be exonerated. I cannot get it. Why? Not because the formal system is not working, but because the formal system is being manipulated by Gacaca. And Gacaca has transformed itself into the Supreme Court of the land. So even in that context, Gacaca is disappointing to me, not because I've studied it comprehensively, but the way that it has impacted upon me and my ability to prove this case has been problematic. Now, this witness is not the only one concerned, because there are other regional authorities that are incarcerated in Woudenberg that expect to be released, whose files have not, a case cannot be built up against them, but no one would, and I've addressed this at some of the highest levels in the Rwandan prosecutor's office, and no one can explain to me why Gacaca should trump a formal adjudication. Now, however, everybody can go through Gacaca. And the law has changed at least 4 or 5 times, which is one of the problems with Gacaca from the perspective of the prisoner, because they don't know what to expect. You know, one day it's one thing, the next day it's another thing, and there's no formal procedural guarantees to push these cases forward. And in this context, it affects a historical erasure, which brings me back to Alison. Because one of the discussions that she and I have had on a number of occasions is that the genocide was a way for Hutu to work out their problems on the backs of the Tutsi. And that does not come through in the Rwandese prosecutions, and I would like to be able to make that point in my case in Arusha, but I'm hobbled in my efforts because of the way the evidence arrives at my desk as it is processed through the Rwandan judicial system. I wanted to talk a bit about the Rule 11 bis transfers, particularly with regard to Alison, because the conscience of our office and the guardian of our institution started to butt heads with our prosecutor, figuratively speaking, over this issue, because Human Rights Watch took a very principled position in opposition to transferring cases from our system to Rwanda. Alison and I discussed many things, and we agreed on many things, and this is the one thing where we did have a disagreement, and it was not on the issue of the position Human Rights Watch took, but it is how they took their position. Because the prosecutor's office claimed that because of the special legislation that was introduced in Rwandan law, that that special legislation exempted ICTR transfer cases, and within that small space that was being created, the Rwandese would be able to provide a fair trial for this discrete group of defendants. And Human Rights Watch took the position that if you look at that discrete space, that was inaccurate. They did not feel that even within that small space and the guarantees that would be specially introduced, that a fair trial would have been possible. And the trial chambers and then the appeals chamber agreed with the Human Rights Watch analysis, because much of what they said was incorporated first in the trial chamber judgment and then in the appeals chamber judgment. But the dispute I had with Alison was not that they took an incorrect position, but their position could have been much broader, because it's not just a little space that is created for these ICTR transfers, but the way that Gacaca operates eviscerates and compromises the entire structure of justice, because even if you can exempt the defendants, or the accused, from the application of Rwandan law, broadly speaking, you cannot exempt witnesses. So if you say, okay, this ICTR detainee who's being transferred to Arusha, to Kigali can have a fair trial, you're not guaranteeing that the witnesses that person calls is going to be exempt from Gacaca, and their testimony in this little special category of cases is not going to come back and haunt them, and they find themselves accused in Gacaca courts. So I thought that the Human Rights Watch position, to be principled, should have been much broader. But true to Lars's analysis, Alison was a pragmatist, and she was not a purist. And she was making, and I mean I say Alison because clearly this is Human Rights Watch's position. This was not Alison's personal project, but we all know who the brains are behind these positions. So I mean, the one disagreement that I can remember that I had with Alison was on an issue of principle, and it was on this very issue. And I must be running out now, but I have to say that Alison was phenomenal. And if you saw her in court, it's amazing. What Laura said is absolutely true. It was a mini lesson. You asked one question and she'd give you a thesis. And not in a showy way that was ostentatious or trying to impress you with her knowledge, but she was really trying to bring you in and lead you along and give you the bits and pieces that you needed at the beginning of her answer to understand the end of her answer. So she was really quite a phenomenon. And Nigel mentioned hearing her testify by telephone. Well, I have to admit that I was the attorney examining her, at least in the direct, when she was on the telephone, and it was very amusing at some points because she was being cross-examined at the time, but you'd hear a little muffle on the telephone, and then you'd hear her yelling to her granddaughter who she was babysitting for at the time. And then afterwards I'd ask her, well, what were you doing? She goes, oh, I was knitting. So see, you can just imagine everybody in court, formal and very staid, with a camera and all of this stuff. There's Alison in Buffalo in the attic, knitting and taking care of her granddaughter. From what I understand, the Bagasora judgment cites Alison 200 times. And she was on the stand for at least a month in Bagasora. And I'm sure the defense regrets it, because if they had not cross-examined her, it would have been a less compelling testimony, because she was always much stronger in cross-examination than she was in direct. And you would think that my long-standing friendship with Alison would have been of assistance to me in examining her, and it wasn't, because we had talked so much, and we had a shared language that, when I'm in court and I have to build things up incrementally, I'd skip steps, because I'm just not as focused on, what I need to ask for an audience that hadn't been in discussion with her. But Alison, true to form, you ask her, what color is the wall? And she come out, well, the Hutu, she would give the answer that needed to be given in order to create a coherent analysis. So she was really special. When she died, I had to be in court following Monday. And I was appearing before a bench that had actually denied her the opportunity to testify. They decided they didn't need expert testimony in the case. And it was a very, very assertive judge. And it was against the defense in my case, very combative. And I had anticipated that if I said anything about Alison's death, that the court would have, erupted, and the defense would have protested, and would have become a big to-do, because similar types of initiatives that I've taken in the past have generated that type of response. But I was determined. Alison was my friend and my colleague, and I am not going to go into court without saying something at the very beginning of the session. And I started out really steeling myself for an outburst from the judge to suggest that it was inappropriate to talk about a prosecution witness dying tragically. And I expected an outburst from the defense. And after, I memorized what I wanted to say, because I wasn't going to let anybody stop me from saying what I had to say. And to my surprise and relief, every single defense team then took an opportunity to praise Alison and her integrity and her scholarship, and then the court came in afterwards. And even though they had denied her audience, which is another point of contention in my trial anyway, the judge recognized her scholarship and expressed its sorrow and regret. I'm sorry I don't have more time to go into more stories, but perhaps afterwards, because I did have a few, but I will...
Thanks. I think I can be short as well over all the merits of Alison de Forge and also about the project, because we heard already a lot. Still, I think we forgot something. We discussed that she couldn't enter Rwanda. I know it very well. I was waiting for her on the 4th of September, and a meeting was planned, and she didn't come. That's not. And then I heard she was refused. And I thought, yeah, well, later, happily I saw her still in France. But it's not only because what she said against the government that she couldn't come back. I think there's a factor we forget. That is the way also the diplomats reacted. They didn't. Or very, not at all, almost. Also I said it to the Dutch, they said, we said so, yeah, we did, we reacted. It is possible, but then they do it, I know the Dutch very well, I'm Dutch, we do it in silent diplomacy. And then you say everything what you want, and nobody has to listen, especially in Rwanda. Rwanda's know it better than I. So you say yes, and we will listen, we will discuss, thank you very much, we will see it, and then it is over. And the diplomat is going away very nicely, and said, I didn't, I protested. But so I think the fact that she wasn't, the second time in December, couldn't come back either, has to do with a changing climate among diplomats in Rwanda. And we discussed already, and I would like to come back. It is the fact that they said, it is a nice little country, it's stable, no chaos. Somebody said no fear, I don't agree, no chaos. And it's on the right road to democracy. Okay, I have another vision, but it doesn't matter. But the diplomats in general don't want anything what is attacking this idea. They don't want to hear. They don't want to hear from the local rights, human rights organization that I think so doesn't ask for mice. They are not interested. And that is very clear. I discussed it then with people from different organizations. I said, at the time, we got support if we had a conflict with the government. It's finished. I said, keep your mouth shut. They're doing fine. Huh? So if you come back, they said, see what's happening in Congo, see what's happening elsewhere, and after they're doing fine. So I think in quoting, for the next time you go to Rwanda, I would like to say something what they say in science fiction films. May the force be with you. And I hope so that you remember that it's not only the Rwandan government that is also pressurizing all the time and remaining very active as the diplomats who don't want to hear you. That's the first thing. The second is about Gacaca. We had a lot of information about Gacaca. And I know Rwanda, so when I was working for the prisons, with a group, my team, and they had with Gacaca. And at the beginning I was quite enthusiastic. I thought, hey, I had worked, so I did some work for the TRC in South Africa, so here's another way to deal with impunity. And I thought, if it's a way what people think in Rwanda could be useful, then I would like to follow it. So I did, and from the beginning, when I heard Alison, she was quite critical about the possibilities. I passed her, I think I became even more critical, but it took some time, as she knew it beforehand. So that was interesting. Then, yeah, somebody said she was truth, and you're looking for the truth, what's going on, facts. And that is very damn difficult in Rwanda, because there's not one truth. There are at least two or three. Now I can say it, because we showed that the ethnicity is still a factor, like your paper, what you said. There are several truths. There's truths from the Tutsis, there's a truth from Wetskape, there's a truth from Hutu, and the Twa have also their own positions and ideas. And it's very difficult to get to the truth. When Mucho, when I met him, was Minister of Justice, he said, so easy. Everybody knows everybody has seen what happened, and it comes out like this. But he's a lawyer, not a sociologist or anthropologist, so I can imagine that but truth is manipulated. Truth is in time changes. Ideas, fear and power relationships make that you can't tell the truth. So all these kind of things make Gacaca very, very difficult. So, but still, and then there's something in the Rwandese culture, but Rwandese can help me. If I say, where are you going? The guy thinks of the woman, so why does he want to know that? What shall I say? What is the consequence if I say where I'm going? So I don't know if you can sit down this better than I do, but I was amazed, and for a sociologist doing interviews, qualitative interviews, I had the same people sometimes over 2 years, and sometimes the story was 180% different from the beginning. So now how I always was looking back to what I saw, and then I said, but you told me that was like this and this and this. I said, yeah, but at the time I didn't know you yet. So it was developing. So you see in a situation, mechanisms, local mechanisms in a village, on the hills. But we were on the hills. Somebody said you have to go on the hills. We were already before he came, but we were on the hills. And there you see these kind of things. And it is difficult, but so petit à petit you get an idea how life on the hills is and how Gacaca is functioning. So now I will do more factual. How many minutes?
Come on, keep going. Like I'm going to cut anybody off.
The best and worst moderator.
So I was very enthusiastic in the beginning because I thought it has internal support. We talked about the international court in Arusha, but I never met anybody in Rwanda who felt it was something important. They didn't trust it. Well, they didn't like it. The national courts, also there, if you had money, you could change things. They didn't like it. Gacaca said themselves, there was a lot of fear and there was a lot of uncertainties, but still it was seen as more important than any other justice project. I said, okay, if it's like this, it remains important. It was accessible and informal. People didn't have to talk French. It was in their own language. And I thought it would be a nice health healing process. Local language, walking distance, sometimes longer if you want to escape the local police for not going, then you left. Single procedures and no professional lawyers. In principle, it was highly participatory. In principle, I said, because it took some weeks only, or people were already rounded up to go there, and the shops were closed, and you had to go there. That became more and more important. It was relatively cheap, especially if you compare it with the international court, and they prosecuted a bit, or they treated more cases than the court. And although there were completely other kinds of cases, and I think the court was necessary. Then there was new, and my organization was working in this field, we had the TIGE, Travail d'Intérêt Général, Community Service Orders. So it was thought about employment of non-custodial sentences. It was never done, I think, for killings, but we saw now they almost mentioned 700,000 persons as accused of participating in one way or another in the genocide. Think with a prison organization what you have to do if you receive all these kinds of people in prison. Impossible. And one of the aims of Gacaca was to empty the prisons and to go much faster. But community service could be a possibility. I thought, interesting. Is it possible? Is it feasible? So that's what I thought. There are so many experiments, there's so many things. Perhaps you can learn a lot of this way of treating this kind of projects, this kind of moment after genocide, after civil war. And there were even some safeguards based on the Gacaca law, but the law changed it all the time, and the safeguards were less important. It became more and more politicized. Then from the beginning, we were conscious that if you mix elements of traditional and modern justice systems, then you have a problem. We see here the so-called traditional, semi-traditional system, and it is applied with a law, written law, where people are trained. So there's some difficulties, and we could discuss it, you know what kind, but it undermines the voluntary nature of the Gacaca. I'm sure of this, and it curtails public participation. So it is a problem if you mix these two sides, these two approaches. And then I think it was difficult. The development was aggravated because too much state intervention, more and more in time, and too little donor accompaniment. And the donors, they liked it. So we told them it would be very good, and they believed it, and they didn't believe anymore when we thought it's less good. So they thought they went on in believing in that we found something new, and that it was good, and that it could be an example. And then I must say, I never saw better politicians than Rwandans. And how to play with the donor people. I'm chapeau. I don't agree, but you must say that they do it in a very well way. So I think that the reconciliation powers of Gacaca are heavily overestimated and not an example to be followed. Because, to repeat a bit the main points that I think where you can really criticize, I said already, it's not truly participatory. People are rounded up, and the reaction is that the Hutu don't say anything anymore. Do you see them often sitting, and the rescapés, the genocide survivors, they say things, some other people, but often the Hutus, they kept silent. And very other important point, but that is also Human Rights Watch, and especially also Lars, who saw that very well, the lack of accountability for RPF war crimes. I don't talk about East Congo, there were enough, but also inside. If you said that, immediately they said, you are like this, you are pro-genocide there. Already working in a prison makes you almost pro-genocide there. I saw that also there. But so, they were very much afraid. So if you said reconciliation, then you have to listen to two groups. Otherwise, then say, but there were not two genocides. And no, there were not two genocides. But there were there were war crimes. And if you want to talk about the past, you have to do this. And they said, no. And they got a lot of problems with a report, with this kind of reports, writing it. And then at the time, we had the ambassador of the United Kingdom, they don't do that anymore now, as I think. You had the Belgians, the Dutch, and the Swedes, they run, and they said, no, he has to, this kind of things he should say. So now it's impossible. I had a Pyrenees friend in Rwanda, he said, you said sometimes, Rwanda's heavy. It's difficult. I didn't understand. Years and years he did human rights activities in Iran. And he said, but there people could discuss in a cafe or in local, in a bus and say, that's government, nothing and so. But here, nobody ever says anything. So if I hear them this morning, and then I sometimes have the idea that I'm in another country, that there is no fear, no uncertainty. I think, gee, that's strange, because I think it is so well controlled that on a certain level, if you say something against the government, there is fear on the political side, absolutely. And it doesn't matter if you're Tutsi or Hutu, you have to keep your mouth shut. So, this accountability for RPF war crimes, immediately you are in the field of the enemy, absolutely, correctly. And that made, so once I was in the near, in the north, and there was a community, I went to the prisons, and they said, do you know that I had 2 genocides? I said, no. Yeah, there are, because, and then from this region, they killed 12 of us. I said, how many did you kill there? Oh, 120. And it's true, you can't measure in things. But if you would have this discussion, nobody could use anymore this kind of arguments. You could say, hey, the reality is like this, there were people killed, sorry for that, they should have gone to court, but you couldn't say anymore that there are 2 genocides. And once the first time when I sat in prison from 12,000 people, and I was in the beginning, it was a big prison, and they said, oh, you want to talk with prisoners? And they opened the door, come in, and they closed it. And I was with my partner, assistant, and to translate, and then you had thousands of people, and I said, gee, I didn't feel it so easy in the beginning. And then they said, do you know what the history is of Rwanda? I said, yeah, I think so. I read everything and talked with a lot of people. You don't know about 2 genocides. And they became angry and said, well, I can give you a list of people who were killed. I said, give them to me. So we came and said, yeah, give them to me. And then, so we tried to, at a certain moment I got fed up, and you don't have to be fed up. It's not good for anthropology, you have to listen, right? I got so angry, and I said, certain moment, I said, and they said, I can't make children with my woman, so that's a genocide. I can't do this, and there's genocide. I said, if there was really a genocide, I had no problem. This prison would be empty. Huh? They looked, and then some ran away, and then others continued to discuss. So these war crimes, but if you come to the side from the government, I was in Illinois, and I said, talk to these prisoners. They said, don't do genocide. I went to the area several times, and we had an assistant working there. They didn't want to participate, the Hutu, in the Gacaca. And then certain people said, no, we want to discuss also the crimes committed against certain Hutus. It was impossible for the genocide, for the Gacaca. So what they did, they organized the Gacaca besides, for these problems. Because they always said, the government, now you can go to the court. But which Hutu who is going to complain about killing Hutus to a government court? Nobody. So they organized a small Gacaca, and I thought that is great. Then why not? If you don't do it in the same thing, make a list of the people who were killed. Because they were in the field, they said all the names of people who were killed. And then 2 names, they said, no, they can't be put on the list. I said, why not? They were killed somewhere else by somebody else. So they were not taken down. I said, but take them down and put them on another list. So I proposed to the government to do this. That was the last time I had some of a good relationship. So it's very difficult in this situation to work. So, okay. So I got more and more critical, and I think yeah, so this victim's justice, you can call it perhaps, and it's understandable because in Holland we are very bad. If you still, years and years, 50 years after the Second World War, we still think, or many think that we were great during the war, Anna Frank, and we helped them, so she got bad luck. But there were more Jews transported from Holland or somewhere else. So it's not that I'm thinking I can say these things only about Rwanda because it's Rwanda. No, we do the same things. Dutch are very bad in this. It's always because I know what I'm talking about. It is very difficult. After the Second World War in Holland, they had a lot of violence against women and children, and some were killed. And we can't discuss this. Only now a book is coming out. So I think, so it is clear. But still, I think you should try to continue to discuss these kind of things. And that is what some people can do much better than I, because I get angry. And but I think you tried, and others, and Alison before. Now there are other points, what makes it very difficult in Gacaca. It's the scale, the nature, and the impact of the genocide crimes. So 80,000 genocide accusations, and that means that criminalizes a big part of the adult Hutu male population. So how do you want to reconciliation if most of the families think, gee, what are they going to do with the guy who's accused? He's going to prison. So why would you, because of some solidarity, because of some fear, why would you participate? You don't lose. Dus traditional gacaca dealt only with relatively small numbers of minor wrongdoings. And here we have killers. First it was now even category 1 are in it, and people who were leaders of people who killed 100 people, still inside gacaca. So if these people are still important and they are around, you're not going to imply, you're not going to say something, you're afraid, so it's better to keep your mouth shut. The context of the crimes are not considered. So it is always, what did you do? Never, what was the context in which it started. So the root causes, and that's why the work of Alison, again, is so important, of the war and the 1994 genocide were never sufficiently addressed in this kind of meetings. Insecurity, people were afraid. There were rumors of a Tutsi witness who was killed, and there were. But there were also Hutu who came back in prison who were killed also. And it is so, you don't need many cases. If you write about it, say, they killed the witness, with all the trauma you have, one was enough to make people enormously afraid. So the insecurity to testify is not guaranteed. But then was a trend, what I said, was increased state coercion and to co-opt or control local justice. And the position until the elected judges was weakened. More and more they left work to be done by appointed people and not by elected people to prepare cases in the gacaca jurisdiction. So it became highly politicized, and like you said itself, it's manipulated by people in power. So that's why I think I listen sometimes with sometimes I'm amazed hearing here that it was, quite positively this morning, and I couldn't find myself. But he said there's a big diversity in opinions. Yes, there is, and there is another one. Thank you.
It was Klaas's diversity of opinion that also helped get convince DFID, I'm sad to say, to stop funding the work that PRI was doing, which was terrific work. I was at a conference that was put on by DFID about 1.5 years ago, where they talked about we need to do more evidence-based work, particularly in the hills. And I raised my hand and said, what about that lovely project you had with Klaas de Jong and PRI? And the guy who was quite high up in DFID said, well, I'm a little embarrassed about that. If it was my decision, I would not have done it. Okay, not very courageous.
We could have killed the project.
Okay, thank you. I'm not sure how I feel about being the last speaker in this conference. Or on the panel then. But I feel very privileged, particularly to share the panel with Klaas, whose work for PRI in Rwanda was absolutely exceptional, as evidenced by the comment from the DFID person. Reflecting on Alison's work, as we have been doing today, for me one of the most impressive aspects of her approach is that she would always judge cases and take up cases purely on their own merits. So whoever the perpetrators and whoever the victims, the bottom line was that if someone's rights had been violated, then that case demanded attention. So the unpopular causes were as important as the popular ones, and the unknown cases were as urgent as the famous ones. So in that spirit, I'm going to talk briefly about one of the most unpopular categories of people in Rwanda, that is the prisoners. I'm not talking about them because they're unpopular, but because I think they're hugely important for the future of Rwanda, particularly because the way prisoners have been treated, to me, illustrates some of the deepest flaws in the government's approach to reconstruction. When I was in Kigali last summer, I met a number of prisoners who'd been released after several years in prison, many years in prison. And for a few days, I saw the world through their eyes. It was just a snapshot of a strange and quite baffling world, where these former prisoners seemed to have no real place and where they just floated around rudderless. In 2004, I'd spent several months carrying out research in Rwanda's prisons, speaking to prisoners about their lives in detention. And I'd found myself at once drawn into that world and revolted by it. There was plenty to be revolted by, not least the inhuman conditions in which people were forced to live, the horror of some of the crimes of which these prisoners were accused, and the absence of justice as they sat there waiting year after year for even the most basic hearing. In my book, I've described some of the suffering that these prisoners and their families have gone through, so I'm not going to detail all that again here. I'll just summarise it very briefly. Many of these prisoners were arrested in the period that immediately followed the genocide. So from July 1994 onwards, thousands of people, tens of thousands of people were arrested at an astonishing rate and stuffed into the prisons, which only had a capacity to hold a very small number. So people were literally living on top of each other with no room to lie down, to sit, no room to even stand at times. So the old, the young, the sick, the men, the women, all were thrown in there together, and thousands of people died as a result of these conditions, particularly between 1994 and around 1999 and 2000. I think it's important to stress that most of these prisoners had never been charged. Many of them had nothing in their case file and had been arrested on what was at that time a kind of blanket accusation of genocide, but without any form of investigation. Now, many of these people may well have been guilty, but had not had a chance to defend themselves or even to hear the charges against them at that time. Many others were almost certainly innocent. So at its peak in around 1998, the prison population reached about 130,000. So by the time I carried out my research in the prisons in 2004, 10 years had passed since the genocide, and some trials had taken place, some prisoners had been released, but the prison population still stood at around 85,500, which is more than 1% of the population of the entire country. And the vast majority of these people, some of whom had been in prison for 10 years, had still not been tried at that time. And despite some improvement, the conditions that they were living in were still very shocking. For some of you who might have read my book or bits of it, it was still the case in 2004 that 40 centimetres was the standard width of the living space of each prisoner. And there are no beds, there's no cells, so each prisoner just had a narrow plank of wood measuring 40 centimetres, and these planks are all lined up next to each other. Some people had to sleep outside because there was no room inside, under the sun or the rain, long queues for water, for toilets, for showers, and family visits lasted just 3 minutes. So to any outsider, these conditions were so obviously cruel and inhuman, it goes without saying, and yet it didn't go without saying, and 10 years on I found that somehow that situation had become accepted and had become normal. So from 2005, things started moving a bit faster, in fact quite a bit faster. Several thousand prisoners were provisionally released, and Gacaca got off the ground, slowly but surely. But Gacaca, as we've heard, was a double-edged sword in the sense that it also resulted in quite a lot of new arrests. So the prisoner numbers went up and down numerous times, and shot right up again as a result of Gacaca in 2007. Mid-2007, the number went up to about 98,000. Then, as Gacaca proceeded and the community service program known as TIJ was introduced, the population gradually went down again. So when I last visited Rwanda about 6 months ago, it stood at just under 60,000. And in fact, the government had organised itself by then, had adopted a national prison plan, something that would have been completely unheard of a few years before, a plan that stretched to the year 2020 with a whole schedule for closure of some prisons, construction of new prisons, production facilities, etc. So in 2009, it is tempting to think that Rwanda's prison crisis is over. And in some ways, it is true that the immediate crisis has passed if we judge that by the life-threatening conditions in the prisons or the number of case files in the prosecutor's offices. But the legacy of that prison crisis can't be disposed of quite so easily. We're not just talking about statistics and numbers here. We're talking about people's lives, people's past, people's memories. And the question now is, where do these people fit into contemporary Rwanda? Last summer I managed to track down some of the prisoners that I'd interviewed in prison 4 years earlier and who'd since been released. It wasn't very difficult to find them. I was lucky I had a former prisoner I'd kept in touch with who helped me track some of them down. Now in the villages and the hills, in the countryside, former prisoners may be very well known after they're released, and they're easily identifiable because everyone knows everyone else. But in Kigali, this is not necessarily the case. They tend to blend in, and they're invisible in a way, except to each other. And yet they're everywhere in Kigali, like a kind of army of ghosts. I spent the afternoon with this former prisoner I'd kept in touch with, and in the first couple of hours we spent together, we bumped into at least 8 other former prisoners, just by chance on the streets of Kigali. And they recognised him, came to greet him, embraced him. Many of them didn't know he'd been released, and vice versa. So even in the cafe where we stopped to have a cold drink, the waiter was also a former prisoner and someone he'd known, so we also chatted to him. And after each of these encounters, which were very brief but quite emotional reunions, he would summarise their cases for me. He would say, for example, oh, that one was in prison for 13 years, or oh, this one used to live in block number 3, or that one, his brother was sentenced to death, or whatever it was. And I realised that these people, in a way, were defined by their imprisonment, but of course only to the initiated. Talking to former prisoners in Rwanda is a strange experience. These should have been happy encounters, and in some ways they were, but these people seemed very ill at ease in their new environment. And I kept remembering what one prisoner had told me several years before. He was talking about others who'd been released, and he said, "We are not free." I think there are several factors here. One is the fear, and I have to support the point that Klaas was making, and I also wanted to pick it up earlier. Fear and uncertainty, to me, are actually the dominant features of life in Rwanda today. And I think for released prisoners, the fear is huge. The fear of being rearrested, because of course many people are rearrested, especially with Gacaca. And that fear still rules their lives, I would say, from day to day. Then there are the more normal, if you like, but still important difficulties faced by released prisoners anywhere, difficulties in finding work, difficulties fitting back into society. But in Rwanda there's an additional feeling that these people who've been defined by the years they've spent in prison are somehow psychologically and emotionally very much outside of the society in which they're expected to integrate. What is very striking is that former prisoners don't talk about the time they spent in prison, not even to their closest relatives, or very rarely. And this former prisoner I kept in touch with, he introduced me to his brother, his sister-in-law. They were very close family. They'd helped him when he was released. And during the course of that conversation, it became apparent that they had absolutely no idea of what this man had endured in prison. People just don't talk about these things. Why is that? I think it's perhaps important to wonder why. Is it because maybe a kind of hierarchy of horror has developed in Rwanda, where people have lived through so much violence and suffering, particularly during the genocide, that life in prison, however harsh, comes out pretty low on the scale. But of course, for those who've lived through it, those memories, they carry them with them all the time. And the extent to which it affects them actually varies. It doesn't always correspond to the gravity of their situation or how long they've spent in prison. Thank you. Some prisoners, some released prisoners, I notice, suffer from a lack of energy and a lack of initiative even to deal with some of the most simple day-to-day problems. And this is in a way surprising because, of course, in prison they've had to deal with things that are just so much more difficult and did so with incredible resilience and inventiveness. But so outside what has happened to them, there is this sudden lack of confidence. And I wondered, is it because they don't know the ropes outside? Of course, in prison, the ropes are created by the prisoners themselves. They're the ones who run the prisons, pretty much. Outside, of course, the rules and the ropes are created very much by the government. And in contemporary Rwanda, I still think that former prisoners are really at the bottom in terms of priorities. There's a complete lack of support for them, even for those who are known to have been wrongfully detained. For example, there are no counselling services or help for them to overcome their trauma, or at least none that they feel able to use. There are counselling services that exist in Rwanda, but the former prisoners assume, rightly or wrongly, that these are reserved somehow for survivors of the genocide. I tracked down another young man I'd met in prison in 2004, and he'd been accused of complicity in a very minor, common crime, not genocide, never charged or questioned, spent 13 years in prison just waiting. And in prison, he struck me as a very enterprising young man. He was keen to learn new skills. He was learning lots of languages. He was engaged and engaging. But when I found him outside, he'd become fearful and detached, seemed to have lost all points of reference and had no idea what he was going to do. So I would like to just go back to the title of this conference, Reconstructing Rwanda 15 Years After Genocide. And I'm wondering what role these former prisoners, and indeed prisoners, if and when they're released, can play in the reconstruction of Rwanda. And I worry that in the repressive political climate that exists in Rwanda today, that these people may find it quite difficult to play a meaningful role in that reconstruction unless attitudes change fundamentally. Among many prisoners and former prisoners, as well as their families, there is bitterness and resentment of what they've had to endure in prison, and particularly the denial of justice for so many years, and at the continuing failure by the government and by society as a whole to acknowledge the wrong that was done to them. One prisoner had told me, and I quote, "The government has created a system of vindictiveness in people's hearts." Now, not all of them feel this way, so I don't want to exaggerate it. Some have adopted a more pragmatic attitude and are just trying to get on with their lives, almost as if nothing has happened, and perhaps they find it more convenient or somehow easier that this painful, very painful episode of their lives remains unacknowledged. So they don't want to wallow in their misery, they go about their business, and they're swept up like everyone else in the frantic pace of change in Rwanda, so they're applying for jobs, learning English, learning how to use computers, learning how to fit in. And some of them are doing okay. But these people's ability at playing at being normal, if we can call it that, hasn't been tested yet in the longer term. And of course the trauma and the fear don't just disappear. This is a whole chapter of their lives which continues to haunt them, and it seems to me unrealistic to expect them to just forget that and get on with things. This gap in their history, it's quite interesting. It's illustrated, I found, quite starkly by the absence of documents that many released prisoners complain about. Several of them told me that it's very difficult to find work because they can't offer a satisfactory explanation for what they've been doing for the previous 10 years. Some had obtained an ID card, but then questions were asked about why it was obtained so late, for example. Or others had only the piece of paper they were given when they were released from prison, but in many cases that just states provisional release because they hadn't been tried. And in fact, some had thrown away this piece of paper because they thought it might become incriminating. One of them told me 10 years unaccounted for. That was his summary of the situation. And because of the large number of prisoners in Rwanda, everybody knows what that means. And everybody also knows that a lot of innocent prisoners have been imprisoned, but still somehow the taboo remains. And it's curious how former prisoners are required to be quite secretive about their past if they want to get on with their lives. It's quite contradictory. One remarkable case is that of a former prisoner who'd spent about 2 years in prison, comparatively short time compared to others. And he, I think, is the only person, as far as I know, who has actually sued the government for wrongful imprisonment. Now, he had the right ethnic and political profile. He's somebody who had been very close to the government. Nevertheless, I think it was a very courageous move. He calculated he could afford to take that risk, and also I should say he was accused of a common crime. He wasn't accused of genocide, but nevertheless. So he made the gamble. But for others, doing this is completely unthinkable. I mean, it doesn't even occur to people. In Rwanda, I think it's become the case that taking 10 years out of a person's life with no legal basis is not even really seen as a wrong. It's just something that's unfortunate, and if these people have been released, then they should consider themselves lucky and get on with it. And to some extent, these are the lucky ones, because there are, of course, those who are still in prison, and one former prisoner described them as those who've been left behind. And amongst those who are left behind in 2009 are undoubtedly some who did participate in the genocide, including some who were accused in Gacaca. But as we've heard, the process of Gacaca has also been flawed, and I think there is still question marks hanging over some of these cases right now. I just wanted to mention briefly the case of a long-standing human rights activist who I've known for many years, who Tom Gibson from Amnesty International mentioned briefly this morning. This man in 2007 was sentenced to 19 years for genocide by a Gacaca court in a case where there was a very clear conflict of interest between himself and the presiding judge. And even though he asked for the judge to be replaced, as is provided for in Rwandan law in such cases, the request was refused. So he was sentenced, the sentence was confirmed on appeal, and then last Saturday the outcome of the review was announced and the sentence confirmed once again. So that's the end of the road for him now. Last summer I visited him in Relima prison. The visits by then had been extended from 3 minutes to 10. But it was hard to know what to say to each other. In 3 minutes it's impossible to say anything, so you don't even try. In 10 minutes you can say some things, but of course you can't have a proper conversation, so perversely I found that it was almost too long. And I found him changed and depressed, but he was holding out for the outcome of that review. the verdict of which was announced last weekend, so that hope has now been extinguished for him. And then there were the stories that just come up in the course of conversations, which rarely make it into the public domain, and these are the kinds of stories that Alison also used to love to tell, and which were so informative, I think, to all of us, because these are the anecdotes of stories that you just don't get to hear about unless you spend a lot of time in the country. And one example, when I was in Rwanda last time, I was speaking to a friend who herself had spent several years in prison, and she was telling me that there had recently been a spate of incidents in which prisoners who tried to escape had been shot dead. And one of them was her cousin. And this cousin, he'd been arrested in 1994. No trial, nothing. Eventually he appeared before a Gacaca court. And apparently no one accused him there of any specific crime, but nevertheless he was sent back to prison. And this was just too much for him after 14 years in prison. He just started going mad. And then out of desperation one day, he tried to escape and was shot dead. And my friend was convinced that actually her cousin, if he'd been heard properly in Gacaca, he would probably have been acquitted. So to conclude, when I first started my work on prisons in Rwanda, several people, including some of my closest friends, suggested to me that this wasn't a top priority and that there were more worthy people to defend in Rwanda, more deserving categories of people. And looking back on Alison's work now, I realise just quite how irrelevant those sort of arguments are, and I hope you'll agree with me on that. To me, the unacknowledged injustices and abuses suffered by many prisoners are likely to have serious long-term consequences for Rwanda's future, and that's really why I wanted to talk about it today. What these people think and do right now is not a peripheral matter at all. We're talking about tens of thousands of people. It's not just a handful of people. It's a big proportion of the population. It's not only prisoners, former prisoners, it's also their families, and most importantly, perhaps the next generation. That is, their children who are struggling to come to terms with what their parents have gone through. And these experiences will shape their future and ultimately the future of the country. And in my view, Rwanda can't afford to ignore them. Thank you.